Welcome to week 2. This week we will be discussing our final capstone paper along with social justice. Our week 2 learning objectives this week include creating an outline for our final paper, analyzing the criminal justice system's effectiveness in advancing social justice, and finally presenting a synopsis of scholarly articles. In Chapter 2, we will look at the typical sections of a research paper. When you hear the words research paper, what comes to mind? Do you instantly get nervous that you have to write another paper? Well, in this class, we will go over all of the parts of the paper. In week 2, we will be working on our outline and gathering sources. So let's get to work. There are a few sections of a research paper, which include the title page, abstract, introduction, literature review, conclusion, and references. As you can see from the picture to the right, this is how a research paper should look. Think of a research paper like a sandwich, or in this case, a hamburger. The top bun would be your introduction. The hamburger would be the meat of your paper, your research. And the bottom bun would be your conclusion. See how all of these things are needed in order to produce a research paper? The Purdue Online Writing Lab offers a lot of great resources when writing your paper. You can access the link in the Week 2 transcripts. Take a look at the sample paper that Purdue Online Writing Lab offers. I have also placed a sample APA template in our classroom under the section Ask Your Instructor. Having a template will help you ensure your paper is in proper format. On the title page, you should include the page number and the running head in all caps, and it's limited to 50 characters. This will be on every single page. Also on the title page, you will include the title of your essay, your name, course number and title, instructor's name, and the due date. Abstract. It should be roughly 120 to 150 words in length, and it should cover the following topics: background and purpose, thesis statement, literature review, and a conclusion. Next, we have the introduction. The introduction has 3 goals according to Robinson and Landrum. Introduce the topic, develop the background, state the purpose and rationale for your paper. If you do not include an abstract in your paper, then the thesis would be located at the end of your introduction. Literature review provides support for the thesis statement, including the rationale for stance. The review should be comprehensive, include all relevant information to show the depth of knowledge and the insight into the topic. The conclusion links the thesis statement to the literature review. Remember, this is the bottom bun of your entire hamburger. You basically wrap up your entire paper. This is not the place to introduce new ideas for your paper. Lastly, in our research paper is the reference page. The reference page provides the intellectual path the author followed to form, shape, and write the paper. You must label your reference page with the word references at the top of the page. Also, we do not number or bullet our sources. The sources on the reference page should be in alphabetical order. Remember, if you need help in citing sources, please check out the Writing Center. In Chapter 7, we will be discussing social justice. So what is social justice? Let's first work on defining what justice is. Justice is defined as the administrating of deserved punishment or reward. Social justice is defined as the fair and proper administration of laws conforming to the natural law that all persons, respective of ethnic origin, gender, possessions, race, religion, are to be treated equally and without prejudice. Civil Rights Act of 1964 and the Women's Right Movement are just a few examples of social justice. Two key figures that bring legitimacy and structure to the movement are Martin Luther King and Cesar Chavez. Social justice includes a few rights. Robinson and Landrum state that social justice include equality, protections that promote equal rights for all persons without discrimination, regardless of characteristics of race, gender, religion, disability, solidarity, union, or fellowship arising from common responsibility and interests, human rights. These are rights regarding as belonging fundamentally to all persons. There are a few different types of justice. Individual justice focuses on outcomes of actions as they relate to individuals. That is, whether or not results are correct. The goal of restorative justice is making the victim and community whole again, with the ideal of restoring the victim and community to pre-crime conditions. Ideological justice is a collection of beliefs that are assumed to produce justice as a result. Distributive justice is justice that is concerned with the privileges, duties, and goods, with the merits of the individual in the best interests of society. Next is procedural justice. This concerns the fairness of processes used when applying the law and is grounded in the idea that fair procedures are the best guarantee for fair outcomes. Due process is the idea that laws and legal proceedings must be fair. The Constitution guarantees that the government cannot take away a person's rights, life, liberty, property without due clause of the law. Perfect procedural justice has two characteristics: independent of what is fair division. 2, devise a procedure that is sure to give the desired outcome. Imperfect procedural justice has two characteristics. Perfect model is seen, but the second characteristic is missing. The purpose of the criminal trial is to prove that an offender actually committed the crime, and the offender should be convicted or declared guilty only if the evidence proves guilty. The imperfect procedural justice operates with the balancing model. Pure procedural justice occurs when fair procedures are established that should produce but do not guarantee a fair justice income. When I think of restorative justice, I think back to a program I saw where it paired victims to the offender, those who committed the crime. This justice is meant to allow the victim to ask questions, get answers, and bring closure to their lives. For the offenders, it gives them the opportunity to make amends to the victim or the victim's family. This restorative justice is achieved by a few techniques: offender to apologize to the victim, mediation, where the victim and offender come together, sentencing circle, offender attends meetings where the victim and or victim's family and or conflict. In Chapter 9, we will be discussing how to use the criminal justice system to create a more just society. The Bill of Rights was enacted to protect our civil liberties and provide equality. A few of the amendments we will be discussing in this class are Amendment 1, Freedom of Religion; Amendment 4, Unreasonable Search and Seizure; Amendment 6, Right to a Speedy Trial; Amendment 8, Excessive Bail, Cruel and Unusual Punishment. Not only is there equality with the Bill of Rights, but we are also afforded equality with law enforcement, courts, and corrections. Law enforcement is the first contact a person has with the criminal justice system. Law enforcement provides equality with the 4th and 5th Amendments. Law enforcement is bound by codes of conduct and agency procedures. Below are just a few of the protections: Amendment 5, Miranda v. Arizona, self-incrimination; Amendment 6, Gideon v. Wainwright, right to counsel; and Amendment 14, Mapp v. Ohio, due process. Under the 5th Amendment, we are afforded the following protections: double jeopardy, self-incrimination. Due process clause means that the government cannot arbitrarily punish people without acting on authority of some written law. The 5th Amendment: no one can be put on trial for a serious crime unless a grand jury decides first that there is enough proof or evidence that the trial is needed. Double jeopardy: if someone is put on trial for a certain crime and the trial ends, the person cannot be tried once more for the same crime. If a person is convicted of a crime and then serves his or her time in jail, or if the person is acquitted, he or she cannot be put on trial a second time. Self-incrimination: you do not have to be a witness against yourself. Under the 6th Amendment, all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed. Speedy trial: the person who is accused of a crime has the right to get a quick trial. This does not mean that the trial will happen in a week, but the state cannot make the person sit in jail for a long time, like 5 years. The person who is accused also has the right to receive a public trial. Impartial jury, which means that jurors cannot be prejudiced or biased against the accused individual. Notice of charges: the accused person has the right to find out what he or she is being charged with. And right witness and counsel: the accused person has the right to make anyone attend their trial if they believe that the person can help their case. Under the 14th Amendment, the Equal Protection Clause of the United States Constitution prohibits discrimination by state government institution. The clause grants all people equal protection of laws, which means that the states must apply the law equally and cannot give preference to one person or class over persons of another. Due process clause protects the First Amendment rights of the people and prevents those rights from being taken away by any government without due process. Due process is a trial by jury for all people accused of wrongdoing. Although you may think that the First Amendment already protects these rights, the 14th Amendment specifically enforces the Bill of Rights on the states to make sure they can never limit the rights of Americans without fairness. Equal Protection Clause. This part of the 14th Amendment states that there may be no discrimination against them by law. The federal government enforces this protection on the states, ensuring that they do not. Next, we will discuss inequality in law enforcement, courts, and corrections. Let's first start with inequality in law enforcement. Law enforcement has seen its fair share of corruption. The solution is to reduce corruption. However, how do we do this? According to the article Controlling Police Corruption by Stuart White, he suggests 3 areas. Hire police officers with good character, screen officers better and reinforce ethical behaviors, and lastly, an incentive program or the method of police chiefs giving promise of contraband going to sub-departments that lack money in the budget. Next is inequality in the courts. The court system can suffer from inequality. 6th Amendment. One way inequality is presented in courts is through having a public defender that is overworked and cannot focus on a case like a paid attorney could. Another inequality is through different crimes, evidence, and witness. One solution would be to hire more paralegals and public defenders. However, this can be a problem when we already have major budget cuts within the criminal justice system. There are other ways to reduce inequality in the courts, which could include reduced sentencing disparity, bringing transparency and accountability, plea bargains, and repealing mandatory minimum sentencing schemes. Lastly, we have inequality in corrections. One area of inequality is rehabilitation. Some prisons do not afford inmates rehabilitation. The solution would be to provide services to all prisons. This is another area of how can we do this when we have budget cuts. However, we have to find alternative ways to provide rehabilitation, such as volunteers, providing group sessions versus individual sessions, or have group-led sessions. Other ways to reduce inequality in corrections include clarifying sentencing laws, control corrections costs by focusing prison space on violent career criminals and addressing the inefficiencies in the corrections and criminal justice system, and protecting public safety by investing in programs, policies, and practices that reduce recidivism. Solidarity implies a special commitment to the most vulnerable. Therefore, solidarity encourages striving for relationships that tend toward equal on the local, national, and international levels. One way this is achieved through law enforcement is through community-oriented policing, problem-oriented policing, and so forth. One way this is achieved through the courts is through the legal and criminal procedures that are provided to all defendants. The procedures of the court system include arrest, defendant taken before a judge within 72 hours, state will provide counsel, opportunity for bail, preliminary hearing, probable cause, and arraignment. If not guilty, then it leads to a trial. This is also achieved through the correction system through maintaining family and community relations. This can be done with nurseries for mothers, transitional centers, reentry programs. Now we will be discussing human rights. First up is human rights in law enforcement. Law enforcement protects human rights by respecting and protecting human dignity and maintains and upholds the human rights of all persons. Examples would be due process, promoting victims as humans, and no discrimination. Another example would be police brutality. Next is human rights in the courts. The court systems protect human rights by the different courts: drug, domestic violence, and mental health courts. An example of a violation of human rights within the courts is determining innocent or guilt and the death penalty. Lastly is human rights in corrections. The correctional system protects human rights through enforcement of punishment. That could include day reporting centers, halfway house, mental and dental programs. An example of a violation of human rights within the correctional system is what happens behind closed doors of the prison system. Lastly, we will discuss the Rodney King case. On March 3, 1991, 4 officers were filmed beating a taxi driver, Rodney King, after a pursuit through the streets. This video was the first of its kind back in 1991. King was under the influence and was caught speeding. When he was pulled over, LAPD started kicking and hitting King at least 53 times. King had bruises, a broken leg, and a scar from a stun gun. The officers involved were acquitted by a majority white jury in 1992. The following 3 days included riots, looting, arson, and violence. I remember seeing a white truck driver being pulled from his truck and beaten in retaliation of the white officers being acquitted. King later sued the city of Los Angeles and was awarded $3.8 million. Where did the police officers go wrong? Did the jury return the appropriate sentence? This week, please do not forget you have 2 discussion questions along with your bibliography. This assignment, you will need to find at least 5 scholarly sources that you plan on using for your final paper. I would highly recommend that you use the Ashford Library to narrow your sources to scholarly journals to ensure you are only using scholarly sources. Once you have your source, then you can discuss each source and why this source is useful to your final paper. Have a great week, and if you have any questions, please remember that I am here to help.